Before we begin, it is critical to understand that this presentation is for informational and educational purposes only and does not constitute legal or medical advice. The laws surrounding involuntary commitment are incredibly complex and vary significantly by state, county, and even by the specific circumstances of the situation. This video is not a substitute for professional legal counsel or medical evaluation. If you or someone you know is in crisis, or if you are facing a legal situation related to this topic, please contact a qualified attorney or a medical professional in your jurisdiction immediately. Imagine getting a phone call. It's your brother, and he's not doing well. He lost his job, his relationship ended, and he's spiraling. In a moment of despair, he says something that scares you, something about not wanting to be here anymore. You're terrified. You don't know what to do, so you call 911 for help. You think you're getting him an ambulance, a wellness check. But what arrives are police officers. And after a brief conversation, they put your brother in handcuffs, place him in the back of their car, and drive him away. He hasn't committed a crime. He's not under arrest, but he has just lost his freedom. He's been placed on a 72-hour hold. What if I told you that every single state in America has a law on the books that allows authorities to detain a person against their will, confine them in a locked facility, and subject them to a psychiatric evaluation, all without a judge, a jury, or a criminal charge? This is the reality of involuntary civil commitment, and it happens hundreds of thousands, if not millions, of times every year in this country. It's known by many names: a 5150 in California, a Baker Act in Florida, a 302 in Pennsylvania, a pink slip in Ohio. But the concept is the same: a temporary, emergency, involuntary hold for psychiatric evaluation. And it is one of the most powerful, controversial, and profoundly misunderstood intersections of law and medicine in the United States. Most people have no idea how it works until it happens to them or to someone they love. And in that moment of crisis, confusion is the last thing you need. That's why we're making this guide. We are going to pull back the curtain on the entire process. We'll break down exactly what a 72-hour hold is. Who has the power to initiate one? What are your rights if you're placed on one? What actually happens inside the hospital? And how do the laws and procedures change dramatically as you cross state lines? By the end of this, you will have a clear, comprehensive understanding of a system that has the power to strip a citizen of their fundamental right to liberty, all in the name of safety and health. Understanding this isn't just academic. It's about protecting yourself and your loved ones. It's about knowing your rights in a moment when you feel you have none. It's about navigating a terrifying situation with knowledge instead of fear. Because when you're in the middle of a mental health crisis, the legal system can feel like an adversary, not an ally. So let's start with the most fundamental question. What exactly is a 72-hour hold? At its core, a 72-hour hold is an emergency measure. It is not a punishment. It is not a long-term solution. It is a legal tool that allows specific, designated professionals to detain an individual who is believed to be experiencing a mental health crisis so severe that they pose an imminent threat to themselves or others, or are considered gravely disabled. The 72 hours part is a bit of a misnomer, and we'll get into the specifics of that later, but think of it as the maximum initial period of observation and evaluation. During this time, the goal is to stabilize the immediate crisis and determine if further, longer-term involuntary treatment is necessary. The entire legal foundation for this rests on three pillars. To be placed on a hold, a person must meet at least one of these three criteria. Let's break them down because the specific language here is everything. The first and most common criterion is danger to self. This is far more than just feeling depressed or having a bad day. The legal standard requires evidence of an imminent threat of serious physical harm to oneself. This is often interpreted as active suicidal ideation. Think about the difference between someone saying, "I just wish I wasn't here anymore," which is what's called passive ideation, versus someone saying, "I have a plan to end my life tonight, I have the means to do it, and I intend to follow through." The second statement demonstrates a specific plan, intent, and access to means. That is what clinicians and law enforcement are looking for: a credible, immediate threat of self-harm. This can also include self-mutilation or other reckless behaviors that are life-threatening. But suicide is the primary driver for this criterion. The second criterion is danger to others. Again, the key word is imminent. This isn't about someone having a bad temper or getting into arguments. This is about a credible threat of serious physical harm to another person. This could be homicidal ideation such as, "I am going to harm my former boss," especially if that threat is specific and believable. It could also be demonstrated by recent acts of violence or aggression that are a direct result of a mental health condition. A person experiencing a psychotic episode who physically attacks a family member, believing them to be a threat, would likely meet this criterion. The danger can't be vague or in the distant future. It has to be a clear and present danger to the safety of others. The third criterion is the one that is often the most complex and most subject to interpretation: gravely disabled. This does not mean someone who is simply making poor life choices, is homeless, or is not taking care of themselves in a way you would like. The legal definition is very specific. A person is considered gravely disabled when, as a direct result of a mental disorder, they are unable to provide for their own basic personal needs for food, clothing, or shelter. Let's unpack that. It's a two-part test. First, the inability to care for oneself must be caused by a mental disorder. Second, that inability must relate to the absolute basics of survival. For example, a person with severe, untreated schizophrenia who is so disorganized in their thinking that they are no longer able to recognize the need for food or water might be considered gravely disabled. Or an individual with severe dementia who wanders out into freezing weather without a coat because they are unable to understand the danger. It's not about having a messy apartment or a poor diet. It's about a fundamental breakdown in the ability to keep oneself alive due to a mental illness. So you have these three pillars: danger to self, danger to others, or gravely disabled. To initiate a hold, a designated professional must have probable cause to believe that a person meets at least one of these criteria because of a mental health disorder. And that belief can't be based on a hunch. It has to be based on specific observable facts, either the person's own words, their recent actions, or credible reports from others. This is the gateway to the entire system. It is the legal justification for taking away someone's liberty. But this raises the next critical question. Who gets to make that call? Who has the immense power to look at another human being and decide, you are a danger, and you are no longer free to leave? That decision, and the people authorized to make it, is where the process truly begins. The answer lies not with a single person, but with a select group of individuals granted extraordinary authority by the state. These are the gatekeepers. And the most common, the one we see most often in movies and on the news, is the law enforcement officer. Imagine a police officer responding to a welfare check. A neighbor called worried. They haven't seen the person next door in days, but they've heard yelling, things breaking. The officer arrives. The door is ajar. Inside, the scene is chaotic. Furniture is overturned. The person is in the corner talking to someone who isn't there. Their words a frantic, paranoid spiral. They haven't eaten. They seem unaware of the cold, of the broken glass on the floor. In that moment, the officer has to make a judgment call. They aren't a doctor. They aren't a therapist. Their job isn't to diagnose schizophrenia or bipolar disorder. Their job is to assess one thing: immediate, tangible danger. They are looking for clear evidence that this person, right now, poses a significant threat to themselves or to others. Is there a weapon? Have they made specific threats? Are they actively harming themselves? Or are they what the law often calls gravely disabled, so impaired by a mental disorder that they can't provide for their own basic needs for food, clothing, or shelter, to the point where it could lead to harm or death? The officer has to document these observable facts. Not the person seemed crazy, but the person was punching the wall, creating a risk of injury to their hand, or the person stated they wanted to end their life and had access to a bottle of pills. Based on these direct observations, the officer can make the decision to initiate an involuntary hold and transport the person to a designated facility for evaluation. This is a power born of necessity, a frontline tool to prevent immediate tragedy, but the police are just one entry point. The second, and arguably more common gatekeeper, is a clinical one. This is the emergency room physician, the psychiatrist, or what many states refer to as a qualified mental health professional, or QMHP. This could be a licensed clinical social worker, a psychologist, or a psychiatric nurse practitioner. Let's change the scene. A family, desperate and terrified, has managed to convince their loved one to go to the hospital ER. The person is experiencing a severe manic episode. They haven't slept in 4 days, they're speaking incoherently, and they're talking about investing their life savings in a nonsensical scheme. They are agitated, but they came voluntarily at first. Now, in the ER, they want to leave. They're demanding to be discharged, insisting they're fine. The ER doctor, after speaking with them and the family, strongly disagrees. The doctor sees the clinical signs of a severe mental health crisis that is rendering the person incapable of making safe decisions. They believe that if this person walks out the door, they are at high risk of harming themselves, whether through reckless behavior, self-neglect, or worse. Here, the standard is similar, but the perspective is different. The doctor isn't just looking at the immediate physical environment like the police officer was. They are conducting a clinical evaluation. They are assessing the person's thought processes, their mood, their perception of reality. And if they determine the person meets the legal criteria for being a danger to themselves or others, or is gravely disabled due to a mental disorder, they can place a hold. They sign a form and suddenly the hospital doors are no longer an exit. The voluntary patient has just become an involuntary one. There is a third path, one that many people don't know exists. This is the route taken when a person in crisis is refusing to engage with police or go to a hospital, but their family or loved ones know, with absolute certainty, that something is terribly wrong. In many states, a family member, or sometimes any concerned adult citizen, can petition a court directly. This is a formal legal proceeding. You can't just call a judge and say you're worried. You have to go to the courthouse, fill out sworn affidavits, and present specific evidence of the person's dangerous behavior. You have to describe recent overt acts or threats. He said he was going to drive his car off a bridge. She hasn't eaten in a week and believes her food is poisoned. He was found wandering in the street, disoriented, talking about fighting invisible demons. If a judge reviews this evidence and finds there is probable cause to believe the person meets the criteria for an involuntary hold, the judge won't issue the hold themselves. Instead, they will issue a court order, a writ, an order of protective custody, for law enforcement to find the person, take them into custody, and transport them to a psychiatric facility for an evaluation. In this scenario, the judge acts as the initial gatekeeper, authorizing others to take action. This process provides a crucial check and balance, ensuring that a person's freedom isn't taken away based on a single person's unsubstantiated fear. It requires evidence. So we have these three main paths: the immediate response by law enforcement, the clinical judgment of a medical professional, and the legal petition by a concerned citizen. But all three paths are guided by the same fundamental principles, the legal bedrock of involuntary commitment: danger to self, danger to others, or being gravely disabled. Let's be crystal clear about what these mean, because the language is incredibly important. Danger to self is not just feeling depressed or saying, "I wish I wasn't here." Legally, it requires something more imminent. It often means a person has expressed a clear intent to die by suicide, has a specific plan, and has the means to carry it out. Or it can mean they are engaging in self-harming behaviors that are life-threatening. Danger to others is similarly specific. It's not just about being angry or yelling. It requires credible threats of physical harm to another person, or actively violent behavior. The threat has to be believable and, in many cases, directed towards an identifiable person. And gravely disabled, the most complex of the three, is a standard designed to protect people who have lost the very ability to protect themselves. This isn't about being poor or homeless or eccentric. It is a direct result of a mental disorder causing a person to be unable to provide for their own food, clothing, or shelter. The classic tragic example is the person in the depths of a psychotic episode, wandering barefoot in a blizzard, completely unaware of the life-threatening danger they are in because their illness has severed their connection with reality. And here is the most critical piece of information: the exact name for the hold, the precise definition of these criteria, and exactly who qualifies as a qualified mental health professional varies significantly from state to state. In California, it's the famous 5150. In Florida, it's the Baker Act. In Texas, it's an order of protective custody. In New York, it's an emergency admission for immediate observation, care, and treatment. Each state has its own statute, its own forms, its own specific rules. But the core concept remains the same. A person's liberty can be temporarily suspended to prevent immediate harm and to allow for an emergency psychiatric evaluation. The gatekeeper, whether wearing a badge or a stethoscope, has made the call. The legal justification has been cited. The paperwork is signed. The door is locked. But this is not an arrest. It is not a punishment. It is the start of a process. And it is the start of a timer. The moment that hold is initiated, a clock begins to tick down. 72 hours. What happens inside those 3 days? What rights are lost, what evaluations are performed, and what does the path out look like? The moment the hold begins is the moment the real story unfolds. The first thing you'll likely notice is the sound, the decisive click of a lock. Not just on the door to your room but the main door to the unit. It's a sound that separates the world you knew from the world you're in now. This isn't a hospital wing where you can wander down to the gift shop. This is a secure facility. Your journey here might have been in the back of a police car or an ambulance, a disorienting ride that ends abruptly at a sally port, a secure entryway designed to prevent escape. Once inside, the process of admission begins, and with it, the temporary suspension of rights you've taken for granted your entire life. The most profound, the most immediate, is the loss of your freedom to leave. You cannot check yourself out. You cannot walk out the door. Pleading, arguing, reasoning, none of it will work. The legal authority of the hold supersedes your personal autonomy. For the next 72 hours, this place is your entire world. Then come your possessions. Your phone, the lifeline to your friends, family, and the outside world is taken. Your wallet, your keys, your belt, your shoelaces. Anything that could potentially be used to harm yourself or others is cataloged and locked away. This isn't done out of malice. It's a safety protocol. But the effect is deeply isolating. You are stripped of your identity markers and your connection to your life. You're given hospital-style scrubs or pajamas to wear. Suddenly, everyone looks the same. The individuality you walked in with is systematically dismantled, replaced by the uniform of a patient. Your right to privacy evaporates. You may be assigned a room with another person, a complete stranger also in crisis. The door to your room might not have a lock, or it might be required to stay open. Staff may perform checks every 15 minutes, day and night, peering in to ensure you are safe. Even the bathroom may offer limited privacy, with doors designed to swing open from the outside or no door at all. You are under constant observation, a feeling that can be both reassuring and profoundly unsettling. What about your right to refuse treatment? This is one of the most misunderstood aspects of a 72-hour hold. In most states, during this initial evaluation period, you cannot be forcibly medicated against your will unless you pose an immediate danger to yourself or others in that moment. For example, if you become physically aggressive. However, the pressure to accept voluntary medication can be immense. A doctor will sit with you, explain the benefits of an anti-anxiety medication or an antipsychotic, and strongly recommend you take it. Refusal is an option, but that refusal will be documented. It becomes part of the data set they are collecting on you, a piece of evidence in their assessment of your insight and cooperation. So while the right to refuse isn't legally gone, exercising it can feel like you're building a case against yourself. This entire 72-hour period is, at its core, an investigation. The primary goal is not to cure you in 3 days. The goal is to assess you, to answer 3 critical questions. Are you a danger to yourself? Are you a danger to others? Or are you gravely disabled, meaning you're unable to provide for your own basic needs like food, clothing, or shelter due to a mental disorder? The investigation begins the moment you arrive. A nurse will conduct a full medical workup. They'll take your blood, check your vitals, and ask about your physical health history. This is crucial to rule out any underlying medical conditions that could be mimicking psychiatric symptoms. A thyroid issue, a vitamin deficiency, a brain tumor, or the effects of illicit drugs can all present as a mental health crisis. They need to know if the problem is in your mind or in your body. Then comes the psychiatric evaluation. You will meet with a psychiatrist. This is the pivotal interview. They will ask you to recount the events that led to the hold. They will probe into your thoughts, your moods, your history. Have you had thoughts of suicide? Have you made a plan? Do you have access to the means to carry it out? They'll ask about voices, paranoia, delusions. They'll assess your speech, your thought process, your judgment. It is an intensely personal and invasive conversation, and every word you say is being analyzed. But it's not just one person making a life-altering decision. Your case will be discussed by a multidisciplinary team. This includes the psychiatrist, nurses, therapists, and a social worker. The social worker plays a key role. They are the link to your outside world. They will likely try to contact your family or friends with your permission if you're able to give it, to get a clearer picture of your life, your support system, and your recent behavior. They gather what's called collateral information, because the person in crisis is not always the most reliable narrator of their own story. As the hours tick by, you'll be expected to participate in the unit's daily routine. Life inside is highly structured. Breakfast, lunch, and dinner are at exact times. There will be group therapy sessions. You might find yourself in a circle of strangers, asked to talk about coping skills or identify emotional triggers. For some, this is a lifeline the first time they've realized they are not alone. For others, it's an agonizing exercise in forced vulnerability. There might be art therapy, music therapy, or time in a day room with a television bolted to the wall and a few well-worn board games. There may be short, supervised periods in an outdoor courtyard, a small patch of fresh air surrounded by high fences. The goal of this structure is to provide a safe, predictable environment, a stark contrast to the chaos that may have defined your life leading up to the hold. The environment itself is engineered for safety above all else. You'll notice the furniture is heavy and hard to move. There are no sharp corners. The windows are made of shatterproof polycarbonate. The shower heads are designed to prevent anything from being tied to them. This is called anti-ligature design. Every detail, from the doorknobs to the plumbing, has been considered to minimize the risk of self-harm. It's a constant, silent reminder of why you are there. Now, in the midst of this disorienting new reality, it is critical to know that you have not lost all of your rights. You have the right to be told why you are being held and what the criteria are for your release. You have the right to humane treatment in a safe environment, free from abuse or neglect. And most importantly, in nearly every state, you have the right to contact a lawyer. This is a right that is often overlooked in the chaos of admission, but it is your most powerful tool. A lawyer can help you understand the process, advocate on your behalf, and challenge the hold if they believe it is not legally justified. Furthermore, facilities are required to have a patient's rights advocate. This is an independent person, not a hospital employee, whose entire job is to help you. They can explain the law, file grievances on your behalf, and ensure the hospital is following procedure. You have the right to speak with this advocate, and their number should be posted prominently on the unit. Knowing these rights exist can be the difference between feeling like a helpless victim and being an active participant in your own evaluation. So the clock continues to tick. The evaluations proceed. The team gathers information from you, from your family, from their own observations of your behavior on the unit. Every interaction is data. Every conversation is a potential piece of the puzzle. They are building a case, and by the end of the 72 hours, which, by the way, often excludes weekends and holidays in many states, meaning it can last much longer than 3 calendar days, they must make a decision. A decision that will determine the next chapter of your life. The hold is not the end of the story. It is a mandatory pause. What happens when the pause ends? There are only 3 possible paths forward, and one of them involves a courtroom. The first path is the one everyone hopes for: discharge. This happens when the clinical team, the psychiatrist, the therapist, the social workers, concludes that you no longer meet the criteria for an involuntary hold. The imminent danger, the storm that brought you here, has passed. But release is rarely as simple as a door swinging open. It's a carefully managed transition. A critical part of this process is the discharge plan. Think of it as a roadmap for re-entering the world. It's not just a suggestion. It's a meticulously crafted strategy for survival and recovery. This plan will typically include scheduled follow-up appointments with a psychiatrist or therapist, prescriptions for medication, and connections to community resources like support groups or outpatient programs. The goal isn't just to get you out of the hospital. It's to keep you out. The team works with you to identify the triggers and stressors that led to the crisis in the first place. Was it a medication issue? A relationship problem? A job loss? The discharge plan is designed to build a safety net around you, to give you the tools and support system to navigate those challenges without ending up back in a crisis. For family members, this is a crucial time to be involved, to understand the plan, and to learn how they can be a constructive part of that safety net. Discharge means the state's authority to hold you against your will has ended. You are free, but it's a freedom that comes with a heavy dose of responsibility. The responsibility to follow the plan and continue the work that started inside those walls. The second path is a fork in the road of your own choosing: voluntary admission. This is a profound shift in status. At the end of the 72-hour hold, the clinical team might say, "We believe you would benefit from continued treatment, but we don't believe you currently meet the legal standard to hold you involuntarily. We would like to offer you the chance to stay as a voluntary patient." The decision is now entirely yours. You are no longer being held. You are choosing to stay. This is a pivotal moment. By agreeing to voluntary admission, you are taking active control of your recovery. You are raising your hand and saying, "I need more help, and I'm ready to accept it." Legally, everything changes. Your rights as a voluntary patient are significantly expanded. Most importantly, in most states you regain the right to request discharge. This doesn't mean you can walk out that exact second. Typically, you have to give written notice, and the hospital then has a short period, often 24 to 72 hours, to either discharge you or, if they believe you have once again become a danger to yourself or others, file a petition to convert your stay back to an involuntary one. But the power dynamic has shifted. The burden is back on them. You are a partner in your treatment, not a subject of it. You have more say in your medication, your therapy, and your daily schedule. For many, choosing voluntary admission is the first, most powerful step toward reclaiming their life. It is an act of courage, an admission of need that is, paradoxically, a profound demonstration of strength. And then there is the third path, the one that leads to a courtroom. This path is taken when the 72 hours are ending, but the clinical team firmly believes that the danger has not passed. They believe that if you are released, you will harm yourself, harm someone else, or are so gravely disabled that you cannot provide for your own basic needs. They cannot legally hold you any longer on the emergency order. Their only option is to ask a court for permission. This is the beginning of a formal legal process called civil commitment. It is one of the most serious intersections of law and medicine that exists. The hospital doesn't just get to decide. They must file a formal petition with the court. This legal document, often called a petition for involuntary treatment, lays out the hospital's case. It will be signed by at least one and often two physicians. It will detail the specific behaviors, statements, and clinical observations that lead them to believe you are still a danger. This petition is not a suggestion. It is a legal accusation. And like any person facing a formal proceeding that could result in the loss of their liberty, you have rights. The moment that petition is filed, a clock starts ticking, and a series of legal protections spring into place. The most important of these is your absolute right to legal counsel. If you cannot afford an attorney, the court will appoint one for you free of charge. This is not a public defender in the criminal sense, but a lawyer who specializes in this specific, complex area of law. Your attorney is your advocate. Their job is not to decide if you need treatment. Their job is to defend your civil liberties and ensure the state meets its very high burden of proof before it can take away your freedom. Your lawyer will meet with you, explain the process, review your medical chart, and prepare your case. You are no longer just a patient. You are now the respondent in a legal case, and you have a defender in your corner. The next step is the commitment hearing. This is the moment of truth. These hearings are often held very quickly, sometimes within a few days of the petition being filed, and they don't always take place in a traditional courthouse. Some hospitals have dedicated courtrooms on site, or the hearing might be conducted via video conference with a judge or a specially appointed judicial officer. But no matter the location, the principles are the same. This is a formal evidentiary hearing. The hospital, represented by its own attorney or a county prosecutor, has the burden of proof. They must prove their case, and the standard of proof is incredibly high. It's not enough for a doctor to say, "I have a gut feeling," or "I think this is for the best." In most states, the hospital must present clear and convincing evidence that you meet the legal criteria for commitment. Let's break that down. Clear and convincing evidence is a legal standard that means the evidence presented must be highly and substantially more probable to be true than not. It's a much higher bar than the preponderance of the evidence standard used in most civil cases, like a contract dispute. It's not quite as high as the beyond a reasonable doubt standard used in criminal trials, but it is specifically designed to be difficult to meet because the right at stake, your fundamental right to liberty, is so precious. At the hearing, the hospital's psychiatrist will testify. They will explain their diagnosis, describe your behavior, and offer their professional opinion as to why you are a continuing danger. Your attorney will then have the right to cross-examine that doctor. They will challenge their assumptions, question their observations, and probe for any weaknesses in their argument. They might ask if less restrictive alternatives to hospitalization were considered. They might question the side effects of proposed medications. This is the adversarial system at work, ensuring that one person's opinion is not enough to strip another person of their freedom. You also have the right to be present at your hearing to speak on your own behalf, and to have your attorney present other evidence or witnesses, perhaps a family member who can speak to your stability or your support system at home. The judge listens to all of it. They weigh the doctor's testimony against your lawyer's arguments. They consider your own words, and then they make a ruling. They can either deny the petition, in which case you must be released immediately, Or they can grant it, issuing a court order for your involuntary commitment for a specified period of additional treatment. Discharge, voluntary admission, or a court order. 3 profoundly different futures, all decided in the hours and days after the initial 72-hour hold expires. And if the judge does sign that order, your world changes once again, leading to a new set of questions about what life is like when you are no longer just being held, but are officially legally committed. The moment the judge's order is signed, the air in the room changes. It's no longer a question of hours, it's a question of weeks, maybe even longer. The legal language might be about further observation and treatment, but the word that echoes in your mind is committed. It's a word heavy with history, stigma, and a profound sense of finality. You are no longer just a person in crisis being held for evaluation. You are now, in the eyes of the state, a patient who requires involuntary confinement for your own safety or the safety of others. The transition from the emergency hold to a court-ordered commitment is often a physical one. You might be moved from an initial observation unit, a place often characterized by acute, short-term chaos, to a different ward, a different floor, or sometimes even a different facility altogether. This new environment is designed for longer stays. The pace might be slightly less frantic, but the reality of your situation becomes more stark, more settled. The doors are still locked. In fact, the security might feel even more permanent, less temporary. The hope that this was all a 72-hour misunderstanding has evaporated, replaced by the cold, hard reality of an indeterminate sentence. Your world shrinks to the size of a single hallway. Life inside a psychiatric unit, once you're committed, is a life of routine. It is a structured, sanitized, and meticulously scheduled existence, designed to eliminate variables and manage risk. The first thing you learn is the schedule. It is the unyielding framework upon which every day is built. It's posted on a whiteboard in the common area, a monolithic testament to the loss of your own autonomy. A typical day begins unnaturally early. A staff member might flick on the lights in your room or call your name, long before the sun is up. 6 a.m. wake up. 6:30 a.m. vitals. A nurse's aide comes by with a blood pressure cuff and a thermometer. You are a set of data points before you're even fully awake. Then comes the first major event of the day, the med line. Twice, 3 times, sometimes 4 times a day, you will line up with your fellow patients at a small window like a bank teller's window carved into a wall. You state your name and date of birth. The nurse on the other side checks your chart, finds your pre-portioned pills in a tiny paper cup, and hands them to you. You are required to take them in front of her, to open your mouth, lift your tongue, and prove you have swallowed. This ritual is a powerful daily reminder. You are not trusted with your own treatment. Your body is no longer entirely your own. Breakfast follows, served in a cafeteria-style common room. The food is institutional, designed for mass production, not for comfort. The utensils are plastic or flexible rubber to prevent them from being used as weapons. You eat at a heavy table, likely bolted to the floor, surrounded by strangers who are now your constant companions. These are the people you will spend nearly every waking moment with. They come from every walk of life imaginable. The successful CEO who had a psychotic break, the college student with crippling depression, the grandmother hearing voices, the young man detoxing from a substance that has ravaged his mind. In this place, all the external markers of status are stripped away. Your job, your car, your family. It all exists in a world outside these locked doors. Here you are all just patients, bound by a shared surreal circumstance. The bulk of the day is filled with group therapy. This is the cornerstone of inpatient treatment. You'll gather in a sterile room on uncomfortable chairs and be led by a therapist or a social worker. The topics vary. There's cognitive behavioral therapy, or CBT, where you learn to identify and challenge destructive thought patterns. There's dialectical behavior therapy, or DBT, which focuses on emotional regulation and mindfulness. There might be art therapy, music therapy, or even something as simple as a goal-setting group. Participation is often mandatory. Sharing your deepest fears and traumas in a room full of strangers feels unnatural, even dangerous. Yet, you are expected to contribute. Some people talk openly, their stories pouring out in a torrent of pain and confusion. Others sit in defiant silence, their arms crossed, their eyes fixed on a point on the wall. And in these groups, you see the raw, unfiltered reality of mental illness in a way you never have before. It's not an abstract concept. It's the trembling hands of the man next to you, the tearful confession of the woman across from you. It is profoundly humanizing and utterly terrifying all at once. What about individual therapy? What about that one-on-one time with a doctor to truly unravel what's happening? This is the part that surprises and often disappoints many. The psychiatrist, the one person with the power to adjust your medication and ultimately recommend your release, is an elusive figure. You might see them for just 10 or 15 minutes once or twice a week. These meetings are rapid-fire check-ins, focused primarily on medication symptoms and risk assessment. How are you sleeping? Are you having any thoughts of harming yourself? Are the new meds helping? There is rarely time for deep therapeutic work. The system is overloaded, and their job is not to cure you, but to stabilize you. Between these scheduled activities, there is an immense amount of empty time. The hours stretch into a long, monotonous blur. You are cut off from almost everything. Your cell phone was taken away upon admission. There is no internet access. The only connection to the outside world is a single payphone on the wall, and there is always a line to use it. Calls are limited to 10 or 15 minutes. You try to explain your reality to a loved one on the other end of the line, but the words feel inadequate. How can you describe the smell of disinfectant, the sound of a distant scream, the feeling of being watched every second of the day? Your personal belongings are severely restricted. No belts, no shoelaces, no drawstrings on your sweatpants. Nothing that could potentially be used for self-harm. You live out of a small bag of pre-approved clothing. Privacy becomes a forgotten luxury. Your room may have a roommate. The door may not have a lock, and staff can enter at any time. They do 15-minute checks day and night, peering through a small window in your door or stepping into your room to ensure you are safe. You are never truly alone. This complete loss of autonomy is one of the most difficult aspects of being committed. Every choice is made for you when you wake, when you eat, when you talk, when you sleep. The goal of this rigid structure is to create a safe, predictable environment where you can shed the overwhelming stress of the outside world and focus solely on getting stable. For some, this enforced simplicity is a relief. For others, it feels like a punishment, a cage that chafes more with each passing day. The very things that are meant to keep you safe, the locked doors, the constant supervision, the removal of personal freedom, can feel like a profound violation. And through it all, one question burns in your mind, a constant, nagging refrain. How do I get out of here? You start to learn the language of the institution. You learn that stabilization is the magic word. You have to prove to the staff, and especially to that psychiatrist you barely see, that you are no longer a danger. You have to participate in groups. You have to take your medication without complaint. You have to say the right things. You begin to understand that your release isn't just about feeling better. It's about performance. You have to convince them you are well. This sets up a complex and stressful dynamic, where you're not just fighting your own inner demons, you're also fighting to navigate a system that holds the key to your freedom. A system with its own set of unwritten rules, expectations, and timelines. And figuring out that path to discharge is a journey all its own. So what does that path look like? What are the steps, the milestones, the gatekeepers you need to get past to have that hold lifted? The first thing you have to understand is that the 72-hour clock isn't a countdown to automatic freedom. It's a deadline. It's the maximum amount of time the facility can hold you without getting a judge involved. The goal for both you and, believe it or not, the hospital, is to resolve the situation before it gets to that point. The most important person in this entire equation is your assigned psychiatrist. Not the ER doctor who admitted you, not the nurses on the floor, but the psychiatrist who will be evaluating you. This individual holds almost all the power in the initial phase. They are the one who will ultimately decide whether to lift the hold early, let it expire, or file a petition with the court to hold you longer. Your entire focus should be on demonstrating to this one person that you are no longer a danger to yourself or others. But how do you do that? It's not as simple as just saying, "I'm fine, I want to go home." They've heard that 1,000 times. They are trained to look past the words and analyze your behavior, your thought processes, and your understanding of your own situation. They're looking for a specific, almost magical quality called insight. Insight, in this context, means you can recognize and acknowledge the circumstances that led to you being placed on a hold. Doesn't mean you have to agree with it. It doesn't mean you have to say, "You were right, I was a danger." But it does mean you can say something like, "I understand that when I said the thing I said, it was alarming to my family, and I can see why they called for help. I was in a state of extreme distress and wasn't thinking clearly." That single statement is worth more than 100 denials. It shows the psychiatrist you're not just fighting the system. You're reflecting on your own state of mind. It tells them you have the capacity for self-awareness, which is a cornerstone of mental stability. Conversely, if you spend your entire evaluation arguing about the legality of the hold, insisting everyone is lying, and refusing to discuss the events that led up to it, you are waving a giant red flag. You're demonstrating a lack of insight, which to them, translates directly into a higher risk. They'll think, if this person can't even see why they're here, how can we trust them not to end up in the same crisis moment the second they walk out the door? The second key component is a credible safety plan. The psychiatrist's biggest fear is discharging you, only to see you end up back in the ER or worse. You need to ease that fear. They will ask you directly, what's your plan for when you leave? A bad answer is, I don't know, I'll figure it out. A terrible answer is, I'm just going to go home and sleep. A good answer is specific, detailed, and realistic. It sounds something like this. When I'm discharged, my brother has already agreed to pick me up. I'm going to stay with him and his wife for the next week. I have an appointment with my regular therapist scheduled for Tuesday at 2 p.m., and I've already called to confirm it. I've thrown out all the alcohol in my apartment. My brother will hold on to my medication and give it to me as prescribed. Here are their phone numbers if you'd like to verify. This kind of plan does two things. First, it provides a concrete, verifiable structure for your immediate safety. Second, and more importantly, it shows that you are capable of forward thinking and problem solving, the very skills that were likely absent during your crisis. You're not just thinking about getting out, you're thinking about staying out. Remember, the psychiatrist is not your only audience. Every single interaction you have on that unit is being observed and documented. The nurse who takes your blood pressure, the tech who brings you your meal, the social worker who asks about your living situation, they are all part of the treatment team. They write notes in your chart. The psychiatrist reads those notes. If you are polite and cooperative with the nursing staff, it gets noted. If you attend group therapy sessions and participate thoughtfully, it gets noted. If you are screaming at the staff, refusing medication, or isolating yourself in your room, that definitely gets noted. Your behavior on the unit is seen as a microcosm of how you'll behave in the outside world. You need to be consistent. The person you present to the psychiatrist must be the same person the nurses see at 3 in the morning. Now let's talk about your rights. In most states, shortly after you're admitted, you should be visited by someone called a patient rights advocate. This person does not work for the hospital staff. They work for you. Their job is to explain the process, to make sure your legal rights are being respected, and to help you navigate the system. Use them. They are your single greatest resource. Ask them to explain the specific criteria for a hold in your state. Ask them what the process is for challenging the hold. They can help you prepare for your meeting with the psychiatrist. They can help you contact family or an outside lawyer. Do not mistake them for just another hospital employee. They are your dedicated ally in a system that can feel overwhelmingly adversarial. But what happens if you do all these things? You demonstrate insight, you create a solid safety plan, you're cooperative, and the psychiatrist still won't lift the hold. This is when the 72-hour clock becomes critical. As that deadline approaches, the hospital has to make a choice: release you or take you to court. If they choose court, they will file a petition for involuntary commitment. This leads to what's often called a probable cause hearing. This is not a criminal trial, and that is a crucially important distinction. The rules are completely different. The hearing might take place in a real courtroom, but more often, it happens right there in the hospital, in a conference room with a judge appearing via video conference. The people in that room will be you, your advocate or lawyer, an attorney representing the hospital, and the psychiatrist who will testify as the expert witness. The hospital's lawyer will present their case, arguing that you continue to meet the criteria for being a danger to yourself or others. The psychiatrist will testify about their evaluation, citing your words, your behavior on the unit, and their professional opinion. Then you or your lawyer get to respond. You can question the psychiatrist. You can present your own evidence, like testimony from family members who can vouch for your safety plan. You can speak on your own behalf, explaining why you believe you are safe to be discharged. But here's the part that shocks most people: the standard of proof. In a criminal trial, the state has to prove guilt beyond a reasonable doubt, which is a very high bar. In a commitment hearing, the standard is much, much lower. In many states, it's clear and convincing evidence, or sometimes even just a preponderance of the evidence, which basically means more likely than not. This means the hospital doesn't have to prove with 100% certainty that you're a danger. They just have to convince a judge that it's highly probable. And judges tend to defer to the opinion of the medical expert, the psychiatrist. It's an uphill battle. The judge is thinking, If I let this person go and something terrible happens, it's on me. If I keep them here for a little longer to be safe, what's the harm? This creates an inherent bias towards siding with the hospital. Winning this hearing is tough. It requires a clear, calm, and rational presentation. It requires poking holes in the hospital's argument. Perhaps they didn't explore less restrictive options, or maybe their evidence of you being a danger is based on a single out-of-context statement from 3 days ago. Having a lawyer or a skilled advocate is almost essential. If the judge sides with the hospital, the 72-hour hold is over, but your ordeal is not. The judge will issue a court order for a longer period of involuntary treatment, often for an additional 14 days, sometimes longer. At this point, the path to discharge resets, and you are now in a much deeper part of the system, a part with its own set of rules and longer timelines. But if the judge sides with you, or if the hospital's case is weak and they withdraw their petition, then you are free. The hold is terminated and you can walk out the door. That moment, when the legal machinery that has held you captive finally grinds to a halt, is a breath of air unlike any other. But getting to that moment requires understanding that you're not just a patient. You're an active participant in a complex legal and medical negotiation where your freedom is the prize. So what does it mean to be an active participant? It means understanding that the moment those doors close, a new set of rules applies to you. And your first, most fundamental right is the right to know what those rules are. In most states, almost immediately after you're admitted, you must be given a written statement of your rights. It might be a photocopied packet of papers, stapled together, handed to you by a nurse who's already halfway down the hall. It's easy to dismiss it. It's easy to let it fall on the bedside table. Another piece of bureaucratic litter in the sterile landscape of your new reality. But that packet isn't junk mail. It's your playbook. It's the game manual for the next 72 hours of your life. It will tell you why you are being held, what criteria they used to make that decision, and what has to happen for you to be released. It will also list your rights, the very tools you need to start advocating for yourself. Reading it, truly absorbing it, is your first act of taking back control. It's the moment you stop being a passive object of the system and start becoming a subject, an individual with a voice. And the most powerful right listed in that packet, the one that can change the entire dynamic of your situation, is the right to legal counsel. Let's be perfectly clear about this. You have the right to a lawyer. If you cannot afford one, one will be appointed for you, usually a public defender or someone from a state-run patient advocacy group. This is not a privilege, it is a guarantee, and you should invoke it immediately. So many people hesitate. They think, I haven't done anything wrong, why do I need a lawyer? Or, this will just make me look more difficult, more crazy. This is a profound misunderstanding of the lawyer's role in this context. Your court-appointed advocate is not there to judge you. They are not an employee of the hospital. Their sole, legally mandated responsibility is to represent your interests. They are your translator for the complex language of mental health law. They are your shield against procedural errors. They are your voice when you feel you don't have one. Think of it this way. The hospital's medical team has a goal, which is to assess and stabilize you based on their professional judgment. But their goal and your goal, which is to be released, may not be the same. The doctor sees a set of symptoms. Your lawyer sees a client whose liberty has been taken away. The doctor is operating under the principle of medical necessity. Your lawyer is operating under the principle of due process. They are the balance in the system. When you request a lawyer, you are not escalating the situation. You are leveling the playing field. You are ensuring that the negotiation over your freedom isn't a one-sided conversation between medical professionals, but a proper legal proceeding where your perspective is forcefully and professionally represented. This single act, saying the words, I want to speak with my lawyer, or I need a patient advocate, can fundamentally alter the trajectory of your hold. Beyond legal counsel, you have the right to communicate with the outside world. This is a critical lifeline. The feeling of being cut off, isolated behind locked doors, can be one of the most psychologically damaging aspects of an involuntary hold. The facility cannot completely sever your ties to your life. You have a right to make phone calls. Now, this right isn't unlimited. The calls may be restricted to certain times of day. They may be limited in duration. A staff member might even be required to be present while you make the call. But they cannot deny you this contact wholesale. This is your chance to call your family, to let them know where you are and what's happening. It's your chance to call your boss and explain your absence. It's your chance to call a friend who can start gathering resources for you on the outside. This connection is more than just comfort. It's a strategic tool. A family member can bring you clothes, contact your lawyer, or start asking questions on your behalf. An informed support system on the outside is an invaluable asset. They are your eyes and ears beyond the walls of the facility, your connection to the life you are fighting to get back to. Don't let shame or fear stop you from using that phone. Your isolation is the system's advantage. Your connection is yours. Now we arrive at the most contentious, the most complex, and often the most misunderstood right of all: the right to refuse treatment, specifically medication. In a normal medical setting, your right to bodily autonomy is paramount. A doctor can recommend a course of treatment, but you have the final say. Inside a 72-hour hold, that principle becomes incredibly murky. The default position in most states is that, yes, you still retain the right to refuse medication. You can say no. A doctor cannot, in most initial circumstances, hold you down and force an injection upon you simply because they believe it's in your best interest. To do so would be assault. However, this right comes with a colossal asterisk. It is not absolute. Your refusal triggers a cascade of events. The medical team will document it. They will likely try to persuade you, explaining the benefits of the medication and the potential consequences of refusal. They will assess your capacity, your ability to understand the nature of your condition and the proposed treatment, and to rationally weigh the risks and benefits. If you refuse and they believe you lack the capacity to make that decision, or that your refusal will lead to a rapid deterioration that makes you a danger to yourself or others, they will not simply give up. They will petition a court. This leads to what is often called a REIS hearing in California, or a similar medication capacity hearing in other states. It's a formal legal proceeding, often held right there in the hospital, where a judge or hearing officer will listen to testimony from your doctor and from you or your lawyer. The hospital's attorney will argue that you are not capable of making your own medical decisions, and that they need the court's permission to treat you against your will. Your attorney will argue the opposite, that you are of sound mind and that your refusal is a valid exercise of your right to bodily autonomy. The outcome of this hearing is a critical turning point. If the court sides with you, the hospital cannot medicate you against your will. If the court sides with the hospital, they receive a legal order empowering them to administer treatment, even if you physically resist. This is a terrifying prospect, and it's why the decision to refuse medication is so fraught with consequence. It can be an act of profound self-advocacy, a declaration that you are in control of your own body and mind. But it can also be interpreted by the medical and legal system as proof of the very illness they are trying to treat, a lack of insight that reinforces their decision to hold you. It transforms your hold from a purely medical observation into an adversarial legal battle. Choosing this path requires careful consideration and, ideally, the guidance of the lawyer you've already requested. It's a high-stakes move in a game where the rules are complex and the consequences are deeply, profoundly personal. Your body, your mind, your freedom, all hanging in the balance of a single decision. So, with that decision looming, what actually happens inside the facility? What are the next 72 hours, or however long your state-specific hold is, really like? The door closes, the paperwork is filed, and the clock, in theory, starts ticking. This period isn't just about waiting. It's an intense, concentrated period of evaluation. The medical team is trying to answer one fundamental question. Do you still meet the criteria that brought you here? Think of it less as a single test and more as a continuous observation. From the moment you arrive, you are being assessed. Every interaction, every conversation, every behavior is a data point. The primary evaluators are typically a psychiatrist, but you'll also likely speak with psychologists, social workers, nurses, and therapists. They are building a case, a clinical picture that will determine your fate. They are looking for evidence, past and present, related to those three core pillars we've discussed: danger to self, danger to others, or grave disability. Let's break down what they're really looking for. When they assess for danger to self, they're not just asking if you have a plan to harm yourself right now. They're looking deeper. Do you have a history of self-harm? Are you expressing feelings of intense hopelessness or worthlessness? Are you refusing to eat or take essential life-sustaining medication for other conditions? It's a broad spectrum, from active suicidal ideation to a passive but dangerous neglect of your own well-being. When they assess for danger to others, it's a similar process. They're looking for evidence of imminent threat. Have you made specific threats against a person or group? Do you have a history of violence? Are you exhibiting aggressive, paranoid, or erratic behavior that could reasonably lead a professional to believe you might harm someone? It's not about thinking angry thoughts. It's about the credible risk of turning those thoughts into actions. And then there's grave disability. This is often the most complex and subjective criterion. It means that, as a result of a mental disorder, you are unable to provide for your own basic needs for food, clothing, or shelter. This isn't about being poor or homeless. It's about being so impaired by your mental condition that you can't use the resources available to you. For example, a person with access to food who is so catatonic they cannot eat, or a person with a warm apartment who, due to severe paranoia, is living on the street in freezing weather. The professional has to prove that your inability to care for yourself is a direct result of the mental illness. During this time, you will likely be placed in a secure psychiatric unit. Your personal belongings will be searched and inventoried. Anything that could potentially be used for self-harm or to harm others will be removed. This means your phone, your laptop, your belt, your shoelaces, and sometimes even the drawstrings on your pants are taken away. This can feel deeply dehumanizing, but from the facility's perspective, it's a non-negotiable safety protocol. They are legally responsible for every single person on that unit. The daily routine is highly structured. Wake-up times, meal times, and bedtimes are fixed. The days are typically filled with a combination of therapeutic activities. You might participate in group therapy sessions, where patients discuss their struggles and coping mechanisms under the guidance of a therapist. You might have one-on-one sessions with a psychiatrist or a social worker to discuss your case, your history, and your feelings about being there. There may be occupational therapy, art therapy, or recreational therapy designed to provide structure and teach coping skills. Now let's talk about the clock. And this is one of the single most important and misunderstood aspects of a 72-hour hold. That number, 72, is incredibly misleading. In the vast majority of states, it does not mean 3 calendar days. It means 3 judicial days or 3 business days. This is a critical distinction. Weekends and holidays do not count. So, if you are placed on a hold at 5 p.m. on a Friday, the clock doesn't really start ticking until Monday morning at 9 a.m. That 72-hour hold can easily become a 96-hour, 120-hour, or even longer stay, especially over a long holiday weekend. This is a shocking reality for many people and their families. They expect a release on Sunday, only to be told that the evaluation period has barely even begun. This isn't a malicious trick. It's because the ultimate authority to extend a hold beyond the initial period rests with the courts, and the courts are closed on weekends and holidays. The facility needs those business days to conduct its full evaluation, and, if necessary, prepare the legal paperwork to petition the court for a longer stay. As this evaluation period, whether it's 72 hours or 5 days, draws to a close, you arrive at a critical fork in the road. Based on all the observations and interviews, the psychiatric team has to make a recommendation. There are only 3 possible paths forward. The first path is release. This happens if the treatment team concludes that you no longer meet the criteria for involuntary commitment. The immediate crisis has passed, you are no longer considered a danger to yourself or others, and you can take care of your basic needs. They can't hold you just because they think you'd benefit from more therapy. If the legal justification is gone, they must let you go. This process is called discharge. A social worker will typically work with you on a discharge plan, which includes recommendations for outpatient therapy, medication management, and support groups. They hand you back your belongings, and you are free to walk out the door. The second path is voluntary admission. The doctor might come to you and say, "Look, we don't believe you meet the criteria to hold you against your will anymore, but we strongly believe you would benefit from continued treatment. We'd like you to stay voluntarily." At this point, the power shifts back to you. You can say no and walk out, or you can agree to stay. If you agree, you sign a form that converts your status from involuntary to voluntary. As a voluntary patient, you have more rights. You can typically have more say in your treatment plan, and, most importantly, you have the right to request to be discharged. In most states, if you want to leave, you have to give written notice, and the hospital then has a short period, often 24 to 72 hours, to either release you or, if they believe you've deteriorated and now meet the involuntary criteria again, file a petition with the court to keep you. It's a compromise, a middle ground between being locked in and going home. Then there is the third path. This is the path taken when the evaluation period is over. The facility believes you still meet the criteria for commitment, and you do not agree to stay voluntarily. You want out, but they are convinced that releasing you would be a dangerous mistake. In this scenario, they cannot legally hold you on their own authority any longer. The initial emergency hold is expiring. If they want to keep you, they must take the next monumental step. They must petition the court for a longer-term, court-ordered involuntary commitment. This is the moment the situation escalates from a purely medical crisis to a full-blown legal battle. The hospital, represented by its attorneys or county council, files a formal petition with the local superior or probate court. This petition is a legal document that lays out the case against you. It details why they believe you continue to be a danger to yourself, a danger to others, or are gravely disabled. It will include statements from the psychiatrist, notes from nurses, and any other evidence they have gathered during your 72-hour hold. When the hospital files that petition, everything changes. The setting is no longer just a medical facility. It's about to become a courtroom, and you are no longer just a patient. You are now the respondent in a legal case where your liberty is on the line. Your opponent is the hospital, an institution with immense resources, now backed by the power of the state. And the stakes? Not just a few more days, but potentially weeks, months, or in some cases even longer periods of your freedom, all to be decided by a judge. And that judge might not even be in the same room as you. In many states, these hearings happen via teleconference. So imagine this. You're sitting in a sterile multipurpose room in the hospital, perhaps still in scrubs or a hospital gown. On a rolling cart in front of you is a television screen. And on that screen is the face of a judge, a disembodied authority figure who holds the next chapter of your life in their hands. You are the subject of the hearing, the reason everyone has gathered, yet you can feel profoundly disconnected from the process itself. It's a surreal, disorienting experience designed for efficiency, not for human connection. In the room with you, or perhaps also appearing as faces on a screen, are the key players in this drama. First, there's the hospital's attorney. Their job is simple: to convince the judge that the hospital is right, that you meet the criteria for further involuntary commitment, and that releasing you would be a mistake. They are not your enemy, technically. They are an advocate for the institution's medical opinion. But in practice, their goal is directly opposed to your freedom. Next, and most importantly for their case, is the psychiatrist. This is the doctor who has been evaluating you since you arrived. They will be sworn in and will testify as an expert witness. They will present their medical opinion, detailing the observations, conversations, and behaviors that led them to conclude you are a danger to yourself or others, or are gravely disabled. They will use clinical language, referencing your diagnosis, your perceived lack of insight, and your refusal of certain treatments as evidence. Their testimony carries immense weight with the court. And then there's your lawyer. If you can't afford one, the court must appoint one for you. This is a critical constitutional right. Your lawyer is, in theory, your champion. Their job is to represent your wishes, to challenge the hospital's evidence, to cross-examine the psychiatrist, and to argue for your release. But let's be realistic about the situation. This court-appointed attorney likely met you for the first time just an hour, maybe even minutes before the hearing. They have a stack of other cases just like yours. They are often overworked, underpaid, and fighting an uphill battle against the perceived authority of a medical doctor. While many are dedicated and fight hard for their clients, they are working with limited time and resources. They are your advocate, but they are not a miracle worker. The central question of the hearing boils down to one thing: the standard of proof. In a criminal trial, the standard is beyond a reasonable doubt. Everyone knows this phrase. It's a very high bar, designed to protect the innocent. But a civil commitment hearing is not a criminal trial. You are not being accused of a crime. The standard of proof here is different. In most states, it's called clear and convincing evidence. So what does that actually mean? Think of it as a scale. Preponderance of the evidence, used in many civil lawsuits, means just tipping the scale 51% sure. Beyond a reasonable doubt means the scale is tipped almost all the way over, maybe 99% sure. Clear and convincing evidence sits somewhere in the middle. It means the judge must have a firm belief or conviction that it is highly probable the hospital's claims are true. It's a higher bar than just more likely than not. But it is significantly lower than the standard required to convict someone of a crime. This is a crucial distinction. The state does not need to prove its case against you with the same certainty it would need to send you to jail. It just needs to convince a judge that you are probably a danger. To meet this standard, the hospital's attorney will build their case piece by piece. They will call the psychiatrist to the stand. The psychiatrist will testify about the initial report from the emergency room, the statements you made, the notes from the nurses on the psychiatric unit. Every observation is potential evidence. Did you sleep? Did you eat? Did you attend group therapy? Did you interact with others? Did you seem agitated? Were you cooperative? Did you have an argument with a nurse? Everything you have said and done since you walked through those hospital doors can and will be interpreted through a clinical lens and presented as evidence to support their petition. They will paint a picture of you, a narrative designed to lead the judge to one conclusion: you are not safe to be released. Then it's your lawyer's turn. They will cross-examine the psychiatrist. They might ask questions to poke holes in the doctor's reasoning. Doctor, isn't it true that my client has been cooperative for the last 24 hours? Isn't it possible that his anger was a reasonable reaction to being held against his will? You mentioned he refused medication, but did you explain the potential side effects to him fully? The goal is to introduce doubt, to show that the evidence is not as clear and convincing as it seems. You also have the right to testify on your own behalf. This is a monumentally difficult decision. On one hand, it's your only chance to speak directly to the judge, to tell your side of the story, to show that you are lucid, rational, and not a danger. On the other hand, you are in an incredibly vulnerable position. You are likely exhausted, possibly medicated, and under immense emotional distress. The hospital's attorney will cross-examine you, and they are trained to ask questions that can make you seem unstable or irrational, twisting your words to fit their narrative. A moment of frustration, a flash of anger, a tearful plea, all of it can be used against you. Your lawyer will advise you on whether or not testifying is a good idea, but ultimately the choice is yours. After all the evidence has been presented and all the arguments have been made, the judge makes a decision. They weigh the psychiatrist's expert testimony against your lawyer's arguments and your own potential testimony. Judges in these cases are often guided by a principle of caution. They are weighing your individual liberty against the potential for harm to you or to someone else. Faced with a doctor confidently stating that a patient is a risk, and a patient who is clearly in distress, many judges will err on the side of safety, which in their view means siding with the hospital. And then comes the verdict. The judge will make their ruling right then and there. There are two paths forward. Path 1. The judge denies the hospital's petition. They find that the hospital has failed to provide clear and convincing evidence that you meet the criteria for commitment. The judge will order your immediate release. The 72-hour hold is over. The legal power the hospital held over you is gone. You are, in that moment, free to go. You can get dressed, sign your discharge papers, and walk out the door. The relief is immense, but the experience leaves a scar. Path 2. The judge grants the hospital's petition. They find that there is clear and convincing evidence that you are a danger to yourself or others, or are gravely disabled. The judge signs a court order. This order converts your temporary, emergency hold into a longer-term, court-ordered involuntary commitment. The 72 hours are over, but your time in the hospital is not. In fact, the clock has just been reset, and this time it's for a much longer period. Depending on the state, this initial commitment order could be for 14 days, 30 days, 60 days, or even longer. You are no longer just a patient. You are now civilly committed. The hospital's authority is no longer temporary. It is now cemented by the full power of the court, giving them the legal right to keep you and to treat you, whether you consent or not. This is a terrifying reality. The legal battle, at least for now, is over. The period of observation has ended, and a judge has determined that your freedom poses a danger to yourself or others. The length of this commitment varies wildly. It could be for a specific period like 15, 30, or 90 days, or it could be indefinite, all depending on your state's laws and the specifics of the court order. During this time, the hospital has the legal authority to administer treatment, most notably medication. This is often the most contentious and frightening aspect of civil commitment, treatment over objection. If you refuse medication that the treatment team deems necessary for your stabilization, they can, with the proper legal and medical authority, administer it against your will. But even in this moment of profound powerlessness, you are not without rights. This is a critical point to understand. Being civilly committed does not strip you of your humanity or your fundamental legal protections. You still have the right to be treated with dignity and respect. You have the right to be free from abuse or neglect. And crucially, in most jurisdictions, you retain the right to ongoing legal counsel. Your attorney's job didn't necessarily end when the gavel fell. They can, and should, remain involved to ensure your rights are protected throughout your commitment. Furthermore, your case must be reviewed. Involuntary commitment is not a life sentence thrown into a dark hole. The law requires periodic reviews of your status. A clinical team, and often the court itself, must regularly reassess whether you still meet the criteria for involuntary commitment. Are you still a danger? Has your condition stabilized? Is there a less restrictive alternative to inpatient hospitalization? These reviews are your opportunity to demonstrate progress and advocate for your release. You also have the right to communicate with the outside world, though this is often restricted. You can typically make phone calls and receive visitors, including your lawyer and a patient advocate. Almost every state has a system of patient advocates or a protection and advocacy agency. These are independent watchdogs, separate from the hospital staff, whose entire job is to investigate complaints and protect the rights of people with mental illness. If you feel you are being mistreated, that your rights are being violated, or that you are being held longer than necessary, contacting the state's designated advocacy group is one of the most powerful steps you can take. They are your allies in a system that can feel overwhelmingly adversarial. So how does it end? The path to discharge begins when the treatment team determines you are no longer a danger to yourself or others. This doesn't mean you're cured. It simply means the acute crisis has passed. You've stabilized on medication, you're participating in therapy, and you've developed a safety plan. The team will then work on a discharge plan. This is a roadmap for your transition back into the community. It includes things like follow-up appointments with a psychiatrist and therapist, arrangements for housing, and connections to community support services. A solid, viable discharge plan is often the final key that unlocks the door. Once the hospital certifies to the court that you no longer meet the criteria for commitment, the court will issue an order for your release. You walk out of the hospital doors back into the sunlight. The immediate feeling is one of relief, but it's quickly followed by a flood of questions and anxieties. What happens now? What are the long-term consequences of what you just went through? This is the part nobody prepares you for. First, let's talk about the record. A 72-hour hold or a civil commitment is a medical event, not a criminal one. It goes on your medical record, which is protected by strict privacy laws like HIPAA. It will not appear on a standard criminal background check that an employer might run for a typical job. However, this is where the nuance comes in. While it's not a criminal record, it is a legal record. The court proceeding for your civil commitment is a public court record in some states, though it's often sealed or confidential to protect your privacy. The most significant and concrete consequence for many people relates to firearm ownership. The standard federal background check form required to purchase a gun from a licensed dealer, Form 4473, specifically asks, have you ever been adjudicated as a mental defective, or have you ever been committed to a mental institution? An involuntary civil commitment ordered by a judge is a yes to that question. Answering yes, or lying and being caught, is a federal felony and will bar you from purchasing a firearm. This is a lifetime ban under federal law. Though some states have a process for restoring these rights after a certain period, it is often a difficult and expensive legal process. For certain professions, the consequences can also be severe. Fields that require extensive background checks, security clearances, or professional licensure, such as law, medicine, law enforcement, or the military, may require you to disclose any history of involuntary psychiatric commitment. Failure to do so can result in the denial or revocation of your license or clearance. It doesn't always mean an automatic disqualification, but it is a significant hurdle that you will have to explain and overcome. Then there is the bill. The financial fallout from a psychiatric hold can be catastrophic. A 3-day stay, even without intensive services, can cost thousands of dollars. A multi-week or multi-month civil commitment can easily run into the tens or even hundreds of thousands of dollars. Even with good insurance, the co-pays, deductibles, and out-of-network charges can be overwhelming. You were brought there against your will, you were treated against your will, and now you are being billed for an experience you never asked for. Hospitals have financial assistance programs, but navigating them is a bureaucratic nightmare, adding another layer of stress to an already traumatic experience. And that is perhaps the most profound consequence of all: the trauma. The experience of being held against your will, of losing your autonomy, of being labeled as dangerous, leaves deep emotional scars. It can create a profound distrust of the medical system and mental health professionals, making it harder to seek help voluntarily in the future. There is the stigma from friends, family, or colleagues who may not understand. There is the self-stigma, the shame and embarrassment that can follow you long after you've left the hospital. So, as we bring this journey to a close, what is the final takeaway? What is a 72-hour hold? It is a blunt instrument. It is a legal and medical mechanism born of necessity, designed to be a last resort in the most desperate of circumstances. It is a system that attempts to balance two fundamental and often competing principles: a person's right to liberty and society's duty to protect its members, including protecting a person from themselves. It is a flawed system, fraught with the potential for misuse, and one that leaves a lasting impact on those who go through it. But knowledge is the antidote to fear. Understanding this process, knowing your rights, and being aware of the potential consequences is the first step toward reclaiming your power. If you or someone you know is in crisis, please reach out. The National Suicide Prevention Lifeline is available 24/7 by simply dialing 988. If you want to learn more about your specific rights in your state, organizations like the National Alliance on Mental Illness, or NAMI, and the American Civil Liberties Union, the ACLU, have incredible resources. The journey through a mental health crisis is terrifying, and the legal system can make it even more so. But you are not just a case number or a diagnosis. Your rights matter. Your voice matters. And most importantly, your life matters. Thank you for listening.